Welcome to Part 2 of the Freedoms of Speech, Assembly, and the Press, First Amendment Freedoms Supporting Civic Discourse. Remember that the video questions and the script are all together for Parts 1 and 2. The freedom to speak publicly, even critically, about government and politics is central to the democratic process. Citizens cannot participate fully in a political system if they are unable to share information, opinions, advice, and calls to action. Citizens cannot hold government accountable if they cannot criticize government actions or demand change. The Supreme Court has made a distinction between pure speech, that is, just words, and advocacy that couples words with actions. With respect to civic discourse, both are important. When speech moves beyond words into the realm of action, it is considered to be symbolic speech, nonverbal speech in the form of an action such as picketing or wearing an armband to signify a protest. Unless words threaten imminent lawless action, the First Amendment will likely protect the speaker. But in civic discourse, words are often combined with action. For example, in the 1960s, anti-war protesters were arrested for burning their draft cards to demonstrate their refusal to serve in Vietnam, and public high school students were suspended from school for wearing black armbands to protest the war. When the two groups brought their case to the Supreme Court, the justices had to determine whether their conduct rose to the level of political expression and merited First Amendment protection. Together, these cases helped to define the parameters for symbolic speech. In the first of these cases, U.S. v. O'Brien, the justices considered whether the government could punish several Vietnam War protesters for burning their draft cards in violation of the Selective Service Act, which made it a crime to destroy or mutilate those cards. The court balanced the free expression guarantee against the government's need to prevent the destruction of the cards. Because the cards were critical to the nation's ability to raise an army, the court ruled that the government had a compelling interest in preventing their destruction. Moreover, because the government had passed the Selective Service Act to facilitate the draft and not to suppress speech, the impact of the law on speech was incidental. When the justices balanced the government's interest in making it easy to raise an army against the incidental impact that this law had on speech, they found that the government's interest overrode that of political protesters. In contrast, when the court considered the other symbolic speech case of this era, Tinker v. Des Moines, they found that the First Amendment did protect the speech in question. In this case, the justices ruled that the political expression in the form of the students wearing black armbands to school to protest the Vietnam War was protected. On what basis did justices distinguish the armbands in the Tinker case from the draft cards in the O'Brien case? They cited legitimate reasons for the government to ban the burning of draft cards in a time of war. The cards were especially important to aid in the military draft. But there was no comparable reasons to ban the wearing of armbands, apart from the school district's desire to curb or suppress political expression on school grounds. School officials could not show that the armbands had disrupted normal school activities. For that reason, the court argued that symbolic speech in Tinker warranted more protection than that in O'Brien. The highly controversial case of Texas v. Johnson tested the court's commitment to protecting symbolic speech of a highly unpopular nature. At issue was a man's conviction under state law for burning the American flag during the Republican National Convention in 1984 to emphasize the disagreement with the policies of the administration of President Ronald Reagan. The Supreme Court overturned the man's conviction, finding that the flag burning was political speech worthy of protection under the First Amendment. After the Johnson decision, Congress quickly passed the Flag Protection Act in an attempt to reverse the court's ruling. Subsequently, however, in the case of U.S. v. Eichmann, the court struck down the new law by the same 5-4 majority as in the Johnson ruling. The decisions in these flag-burning cases were very controversial and have prompted Congress to pursue the only remaining legal avenue to enact flag protection statutes, a constitutional amendment. Indeed, each Congress since the Johnson decision has considered creating a flag desecration amendment. Every other year from 1995 to 2006, the proposed amendment has received the 2/3 majority necessary for approval in the House, but it has consistently failed to achieve the same constitutionally required supermajority vote in the Senate. Senate opponents of the ban argue that the ratification of the amendment would undermine the principles bolstering the meaning of the flag. Although the amendment is still regularly proposed in both houses, in recent years it has not moved from committee consideration to a vote on the floor. The Supreme Court long ago rejected the extreme view that all speech should be free in the United States. Whereas political speech tends to be protected against government suppression, other forms of speech can be limited or prohibited. The courts afford commercial speech, that is, advertising statements, limited protection under the First Amendment. According to the Supreme Court, commercial speech may be restricted as long as the restriction seeks to implement a substantial government interest, directly advances the interest, and goes no further than necessary to accomplish its objective. Restrictions on tobacco advertising, for example, limit free speech in the interest of protecting the health of society. In 2010, the Supreme Court, in the controversial Citizens United versus FEC decision, revised its previous ruling and determined that the First Amendment also protected corporate spending during elections as a form of free speech. Legislation that limits such spending was an unconstitutional ban of political speech. Other forms of speech, including libel and slander, receive no protection under the First Amendment. Libel, written statements, and slander, verbal statements, one way you can remember that is slander and said both start with an S, are false statements that harm the reputation of another person. To qualify as libel or slander, the defamatory statement must be made publicly and with fault, meaning that reporters, for example, must undertake reasonable efforts to verify allegations. The statement must extend beyond mere name-calling or insults that cannot be proven true or false. Those who take a legal action on the grounds that they are victims of libel or slander, such as government officials, celebrities, and people involved with specific public controversies, are required to prove that the defendant acted with malice, with knowledge that the statement was false or recklessly disregarded the truth or falsity of the statements. Obscenity, indecent or offensive speech or expression, is another form of speech that is not protected under the First Amendment. After many unsuccessful attempts to define obscenity in 1973, the Supreme Court developed a three-part test in Miller v. California. The court ruled that a book, a film, or another form of expression is legally obscene if, this is the three-prong test. So make sure you write this down. The average person applying contemporary standards finds that the work taken as a whole appeals to the prurient interests, that is, tends to excite unwholesome sexual desire. Secondly, the work depicts or describes in a patently offensive way a form of sexual conduct specifically prohibited by an anti-obscenity law. Or thirdly, the work taken as a whole lacks serious literary, artistic, political, or scientific value. That's known as the LAPS test. L, literary, A, artistic, P, political, S, scientific value. Of course, these standards do not guarantee that people will argue upon what materials are obscene. What is obscene to some may be acceptable to others. For that reason, the court has been reluctant to limit free speech, even in the most controversial cases. The court may also ban speech known as fighting words, speech that inflicts injury or results in public disorder. The court first articulated the fighting words doctrine in Chaplinsky v. New Hampshire, 1942. Walter Chaplinsky was convicted of violating a New Hampshire statute that prohibited the use of offensive, insulting language toward persons in public places after he had made several inflammatory comments to a city official. The court, in upholding the statute as constitutional, explained the limits of free speech. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. Thus, the court ruled that, like slander, libel, and obscenity, fighting words do not advance the democratic goals of free speech. Cross-burning, for example, has been a form of symbolic speech that in the United States has come to represent racial violence and intimidation against African Americans and other vulnerable groups. In 2005, the Supreme Court in Virginia v. Black found that a state could ban cross-burning when it was used to threaten or attempt to silence other individuals, but that the state law could not assume all cross-burnings attempt to communicate that message. Even the types of unprotected speech we have considered enjoy broad protection under the law. Although cigarette ads are banned from television, many products are sold through every media outlet imaginable. Though a tabloid such as the National Enquirer sometimes face lawsuits for the false stories it prints, most celebrities do not pursue legal action because of the high burden of proving that the paper knew the story was false. intended to damage the subject's reputation, and in fact, cause real harm. Even though network television is censored for broadcasting objectionable material, the Supreme Court has ruled that the government cannot ban adult pornography on the internet or on paid cable television channels. The court even struck down a ban on the transmission of virtual child pornography, arguing that no real children were harmed in the creation of these photographic or computer-generated images. And, despite continued reaffirmation of the fighting words doctrine, the Supreme Court has declined to uphold any convictions for fighting words since Chaplinsky. In short, the court is reluctant to do anything that might limit the content of adults' free speech and expression, even when that speech is unpopular or offensive. The First Amendment says that people have the freedom to assemble peaceably and to seek redress of compensation for grievances against the government, yet there are limits placed on assembly. As the Supreme Court has considered free assembly cases, it has been most concerned about ensuring that individuals and groups can get together to discuss their concerns and that they can take action in the public arena that advances their political goals. The court's stance in free speech cases provides insight into its leanings in cases concerning freedom of assembly. The court is keenly aware of the need for order in public forums and will clamp down on speech that is intended and likely to incite public unrest and anger. That is one reason the court has reaffirmed the fighting words doctrine. Although officials cannot censor speech before it occurs, they can take action to limit speech once it becomes apparent that public disorder is going to erupt. In its rulings, the court has allowed content-neutral time, place, and manner restrictions. Regulations regarding when, where, or how expression may occur. Such restrictions do not target speech based on content, and to stand up in court, they must be applied to a content-neutral manner. For example, people have the right to march and protest, but not while chanting into bullhorns at 4 o'clock in the morning in a residential neighborhood. The court's rulings in these various cases illustrate how the government is balancing the freedom of assembly against other concerns, notably public safety and the right of an individual to be left alone. The court is carefully weighing the freedoms of one group of individuals against another and attempting to ensure the protection of free public expression. Throughout American history, the press has played a crucial role in the larger debate about political expression. Before the War for Independence, when the British monarchy sought to clamp down on the political dissidents in the colonies, the King and Parliament quickly recognized the urgency of silencing the press. A free press is essential to democratic ideals, and democracy cannot survive when a government controls the press. The First Amendment guarantee of free press ensured not only that American government remains accountable to its constituents, but also that people hear competing ideas about how to deal with matters of public concern. Increasingly, the Internet has become the place where ordinary citizens share their views on important political issues. Ensuring a free press can complicate the work of government. Consider the challenge presented to the George W. Bush administration when the New York Times broke a story in late 2005 that the National Security Agency, or NSA, had began using futuristic spy technology against thousands of individuals inside the U.S. The NSA is responsible for monitoring the communications of foreigners outside U.S. borders and does not have authority to engage in surveillance of Americans in the United States. Moreover, the Fourth Amendment protects Americans against searches without either a warrant or a court order. Despite claims to the contrary during his campaign, President Obama has not changed that policy and has sided with the Bush administration in legislation challenging it. Certain well-established principles govern freedom of the press in the United States. First and foremost, the courts almost never allow the government to engage in prior restraint. Prior restraint means censorship, the attempt to block the publication of material that is considered to be harmful. The Supreme Court established this rule against censorship in 1931 in the landmark case of Neer v. Minnesota. After editor Jay Neer wrote a story in the Saturday Press alleging that Jews were responsible for corruption, bribery, and prostitution in Minneapolis, a state judge barred all future sales of the newspaper. The court overturned the state judge's ruling, finding that the sole purpose of the order was to suppress speech. Because freedom of the press has strong historical foundations, the court concluded censorship is clearly prohibited. In the Neer ruling, the court recognized, however, that there might be times when government officials could limit the publication of certain stories. Specifically, such censorship might be justified under extraordinary circumstances related to ensuring public safety or national security, or in cases involving obscenity. In reality, though, the court has disallowed prior restraint in the vast majority of cases. For example, in the most important case examining the national security exception, New York Times versus U.S., 1971, the court rejected the government's attempt to prevent publication of documents that detailed the history of the United States' involvement in Vietnam. In this case, also known as the Pentagon Papers case, the government argued that censorship was necessary to prevent irreparable injury to national security. But the court dismissed that argument, asserting that full disclosure was in the interest of all Americans and that publication of the documents could contribute to the ongoing debate about the U.S. role in the Vietnam War. In their ruling, the justices recognized that some materials are clearly necessary for full and fair discussion of issues facing the nation, whereas others are far less important to political discourse. The court, for example, has allowed the government to censor publications that are far less central to public debate, such as obscene materials. The court is far more willing to allow the government to impose constraints on broadcast media than on print media. Why should a distinction be made between print and broadcast media? Probably the most important justification is that only a limited number of channels can be broadcast, and the government is responsible for parceling out those channels. Because the public owns the airwaves, the people may also impose reasonable regulations on those who are awarded licenses to operate broadcast channels. The court views the Internet to be more like print media than like broadcast media. Thus far, the court has signaled its interpretation that the Internet is an enormous resource for democratic forums, one that allows users access to virtually unlimited sites at very low cost. That was the decision in Reno versus ACLU, 1997, and Reno comes from the Attorney General at the time, Janet Reno. The court's fine distinctions are between media that allows more and media that allows less access to individuals and groups to engage in political discourse. The court's assumption is that print media and the Internet provide relatively cheap and virtually unlimited access and enable people to tap easily into discussions about issues facing the nation. In contrast, broadcast media, with much scarcer channels, represents a much more limited arena for dialogue and thus can be reasonably regulated.